Good morning or good afternoon, I guess, depending on where you are in the country. Hopefully you can hear me and see me okay. Thank you very much for having me here today. Today we're going to talk about preparing your clients for wealth transfer, taxation options, solutions, and strategies. I'm going to try and share with you some stories that sell. So I think we've all heard the statistic out there. It may vary between the amount of money that might be transferred over the next decade. We call it a wealth tsunami. The number I've heard is $1 trillion, which I think presents great opportunity and risk for your clients and as well for you as financial advisors. From a client perspective, I think the opportunity here is for a lot of individuals, they've saved, they've worked hard, they've saved, they've accumulated assets, or even the value of their home is appreciating value significantly. So they have an estate that they want to pass on to their loved ones, that next generation, to make their lives easier. But the risk for them is that those assets do not go to the individuals that they intended in the manner or timing in terms of when they get them, or it's not done in a tax efficient way, a cost effective way, or done on a timely basis. A lot of those clients are concerned about what their beneficiaries are going to do with the money. Will there be money left for their grandkids? There's case after case in the news where unfortunately clients, especially the do-it-yourselfers, really struggle, make tragic mistakes. In fact, I'll talk about a case later on just to show you how prevalent this is. This could be your neighbor. It could be your children's friends or playmates or coaches from their sports team or dance teams, etc. It is an epidemic across the country. The good news is there's an incredible need and demand for your services. And I really think that nobody's in a better position to quarterback clients' estate plans than advisors, than you guys. So from an advisor perspective, there's great opportunity and great risk as well. The opportunity, again, if we use $1 trillion as the amount of money that's going to be transferred, the asset value that's going to be transferred over the next decade, does anybody know what that means on a daily basis? Well, if you're good with math or have a calculator handy, $1 trillion divided by 365 days for 10 days a year works out to about $275 million in motion every day. That's a pretty staggering amount. So obviously, with so much money in motion, a great opportunity for advisors to attract assets, retain assets. Obviously, the risk, though, with assets in motion is that if the clients are unhappy with you, or when assets move to the next generation, this is a huge risk. And there's all sorts of statistics out there, studies out there as well, too. When assets move to the surviving spouse, or particularly when they move to the next generation, assets often leave the advisor. But a great way of retaining those assets or growing your asset base is through estate planning. Estate planning provides a great opportunity, an excuse to talk about that next generation, to have those conversations with the next generation. Maybe you have a client meeting to talk about what the client's estate plans are, go through their wills, so that they have a chance to explain what their estate plans are. The beneficiaries have a chance to hear, ask questions, and get an answer from their parent or sibling, whoever it might be, before they pass away. So those type of client or estate planning meetings can be very, very valuable. And seg funds, with their estate planning features, are a great asset or tool in your toolbox to help with that estate planning and as well with those conversations with the next generation. So just to give you a little bit of a segue here, I'm going to go into really what is, I think, a very tragic case, but I think a real life case. This could be any of our neighbors. This is Diane Taylor, and this was in CBC News a little while ago, and really actually quite a sad case. I set out the facts here for you. Diane was married to Tim. They were married with a 13-year-old daughter. Tim was 50 years old, and tragically, Tim woke up one day feeling incredibly ill. His stomach was incredibly sore. They rushed him to Emerge, and they diagnosed him with stage 4 cancer. And he died within a few weeks of that diagnosis. So very sad. So Tim was a banker, so you would expect him to be financially astute and knowledgeable. And his will, Diane and him had mirror wills. So his will said, everything goes to his wife, Diane. And one of his most significant assets was an RSP worth about $685,000. And Diane was really counting on those assets to help take care of herself and their daughter after Tim's passing. Unfortunately, as they went through the estate documents, they realized that Tim, when he had set up the RSP, he had named his mother as beneficiary, and subsequently to getting married to Diane, had failed to change the beneficiary designation to Diane. And by all accounts, it seems the intention was for everything to go to Diane. Like I said, the will, everything went to Diane. So now Diane's in a situation where the most liquid, the most valuable asset they have there is actually going to her mother-in-law, to Tim's mom. So I would have just assumed that Tim's mom would have renounced the beneficiary designation. So the asset would have flown through the estate and be dealt with according to Tim's will, which meant that everything would have gone to Diane. And she could have rolled it over to her RSP on a tax-deferred basis. It would be subject to probate, which would be very unfortunate. And actually, Nova Scotia has the highest probate fees in the country of about 1.7%. So she would have incurred an additional $11,500 of taxes, which is unfortunate, but still, I guess, a small price to pay in this situation. But Tim's mother refused to renounce, if you can believe it. So Diane obviously wanted the funds. She spoke to a lawyer. She started litigation. And what they realized, and I actually spoke to the lawyer in this case, the lawyer said, well, the problem was in Tim's will, he just had a general revocation clause. He did not specifically identify that RSP contract and that he wanted the beneficiary revoked from the mother to Diane. And as a result, there was case law in Nova Scotia that said that when you have a general revocation clause in your will, that's not valid against an RSP, and therefore the mother or mother-in-law's beneficiary designation was going to be valid. Now, the good news is there is a little bit of a saving grace here, is Diane and her mother-in-law were able to negotiate a settlement, an out-of-court settlement. Tim did have another life insurance policy of about $300,000. And so the mother-in-law said, well, if you sign over that life insurance policy to me, I'll renounce the beneficiary designation. And that's what they did. And one thing I forgot to mention here that's very important, one of the other kickers, if the mother-in-law had not renounced the beneficiary designation, so she would have received the $685,000 of RSP money, guess who would have paid the tax? Well, the tax liability would have been to Tim and Tim's estate, and Diane, as the mother, would have had that tax liability. So not only would the $685,000 gone to her mother-in-law, but she would have had an incremental tax bill of well over $300,000. Talk about a real punch in the gut. So anyway, things did kind of work out in the sense that the mother-in-law renounced. Diane had to sign over a life insurance policy. And Diane was really surprised. And one of the comments that she made was she thought an RSP was like a pension plan. And LIRAs come under pension plans where a spouse, if you have a spouse, is automatically the beneficiary unless they waive their rights. But an unlocked or a regular RSP does not have that provision. So there is no kind of first right of refusal to the surviving spouse. So that's very, very important. So you think about this scenario, Tim was probably a do-it-yourselfer, probably thought he was financially astute, forgot to update his beneficiary designation. And not only were there significant costs and delays here, but also think about the family relationship. We just had Christmas, we just had the holidays. I'm guessing there's a really good chance here that Diane and her mother-in-law did not spend the holidays together. And if that's true, and I hope it's not, but if that's true, I mean, that's a real shame here. I'm sure Tim, that would have been the last thing that he would have wanted to somehow create a toxic environment between his widow, his wife, and his mother-in-law. So it really gets back to the value of planning. And unfortunately, Tim didn't have a financial advisor like one of you that could have helped him to review the beneficiary designations. So again, this is just an example of the epidemic, the need, the crisis here for estate planning and the value that you guys can provide. So segregated funds, and when I say segregated funds, it's important for me to mention, I'm including GIA, so guaranteed interest accounts. So the insurance company version of a GIC, the ability to name a beneficiary, particularly in non-reg assets, has many significant benefits. One of them is the quick death benefit payout. If you name a beneficiary on a segregated fund or a GIA, we will pay out the death benefit within 2 weeks of receiving all the death claim documentation. And that is a very, very powerful tool. And I ask you to think even about yourself. Think about a situation where if you were to pass away, how important it is to you for your beneficiaries, your heirs, to receive those funds within a couple of weeks, as opposed to waiting potentially months or years. But I would also ask you to think about if your clients pass away right now with stocks or mutual funds or assets without a beneficiary designation, even a GIC, for example, what happens to those assets? My understanding is that in most cases, those assets are frozen until you receive probate in the provinces that require probate. So every province other than Quebec. And probate can take, best case scenario, can take a few months. But if there's any type of issues of identifying the executor, or people maybe refusing to be the executor, or there's any type of estate litigation or challenges or confusion, it can easily take 6 months, 9 months, or well over a year. So you think about clients' beneficiaries or your beneficiaries. Wouldn't they be in a much better position where they had some money that they could then pay the expenses? Because the expenses don't stop, the bills don't stop, the mortgage payments, the tuition, the car payments, property taxes, those expenses don't stop. But if they will receive some money, and we call it a sleeve argument here, a sleeve strategy, even $100,000 to provide liquidity to the estate or the beneficiaries, so they can pay the bills and not have to worry about the bills, and then instead can focus on mourning the loss of a loved one. Very, very valuable. I have advisors who haven't sold any segregated funds or GIAs, and I'll put $100,000, $20,000 into a seg fund or GIA just to provide that liquidity to the estate. And you think about somebody who perhaps died in January of this year, and their assets have been frozen up until, or January of last year, sorry, and their assets have been frozen until now. Well, all they're seeing probably is the value of those assets going down over time, as opposed to getting that death benefit check and doing whatever they want, even paying down debt. Because now people with mortgages, variable rate mortgages, those rates are going up. One of the other really important benefits of having assets flow outside of the estate by naming a beneficiary is it reduces the work, the risk, and the stress on your executors. David Chilton, the author of The Wealthy Barber, who you probably know, has a great quote about this. He says, "I'll do anything for my friends except two things. I won't help them move because I'm too old, and I won't be their executor because I'm too smart." Being an executor is a thankless job. By having assets flow outside of the estate, you have less things for them to worry about from a stress perspective, from a work perspective, and a potential personal liability, because executors can be personal liable in certain situations. If you have non-resident beneficiaries, so the kids have moved to the US or abroad, that is fraught with potholes and risks for executors. As a simple example, if you're an executor of an estate and you're holding on the assets until you pay off all the creditors or before you get the tax clearance certificate. The tax clearance certificate is something that when you file the final tax return of the deceased, you get that CRA called clearance certificate. It gives you a green light that the taxes are in good order and you can start paying out the assets of the estate. Well, while you're waiting for all of that to happen, you as executor probably have the assets of the estate invested in a high interest savings account. Well, any interest income earned on that high interest savings account or a GIC, for example, that belongs to a non-resident beneficiary, you as an executor must actually remit and withhold tax to the CRA on that interest income. And if you don't, you're personally liable. So again, by having assets flow outside of the estate, makes it a lot easier for your executor, reduces their risk. Google Terry Dooley. He was the executor for a friend of his. He was an accountant and he was an executor for a friend of his. And he has a great quote. It says, "I was the executor of an estate and it cost me 7 years of my life and $100,000 of my own money," his own money. Never mind the fact that he didn't get $300,000 of executor compensation. And one point I want to mention, because I forgot to mention this at the very beginning, if you do have questions, you can put in the Q&A. I do see a question there, and I've been told these will be forwarded to us, and we will answer these after the presentation. The third really key or big benefit that I think comes with naming a beneficiary is that you're not cut out by the executor. Instead of the assets going through the estate and all the disadvantages that come with that, the other disadvantage is the executor is the one that cuts the check to the beneficiary. This way, you're still involved in the process. You can actually physically deposit or transfer the check to the widow or the children. Again, just reinforcing your value, giving you an opportunity to put your arms around the clients in the next generation and hopefully retain those assets. And lastly, by having the assets flow outside of the estate, you're avoiding probate. Not only the fees, but when a will is submitted for probate, it becomes a matter of public record. And that means anybody can go down to the courthouse and get a copy of a client's will. I have a copy of Rob Ford's will. I know that Doug Ford is the executor. I know that his estate is divided one third between his wife and two kids. I know his two kids' date of birth and middle names is actually quite scary. So if privacy is an important benefit for your clients, having assets flow outside of your estate by using a beneficiary designation with a seg fund or a GIA can be very, very valuable. And just to give you an example, with Rob Ford, that case has played out in the public media. That estate is worth $1.1 million. It's been subject to a significant estate litigation. They've already spent over $440,000 of legal and accounting fees between the executor, Doug Ford, and the widow, Renata. So again, making life simpler, having assets flow outside the estate and pay directly to a beneficiary can save time and money. So what I've done on this next slide is I've tried to encapsulate all of the potential benefits that a seg fund or GIA can offer. And I've talked about some of them here with the quick death benefit payout, but there are so many more. And I won't get into this now. I do have another opportunity to speak to you on February 9th. So hopefully this is a bit of a teaser, but I'll get into a lot more of these potential strategies that can have a significant benefit for your clients from an estate planning perspective. One benefit you will realize in the next month or two is that with segregated funds, all taxable events report on a T3. So it makes clients' tax return filing a lot easier. Unlike stocks or mutual funds where only the dividends or distributions are reported on a tax slip. So it makes it a lot easier. But there's a lot of really great strategies. Segregated funds are very flexible. So there's a spousal rollover, borrow a life, strategies when clients have lost capacity and what you can do with the money with the POA, an irrevocable beneficiary strategy, structuring a death benefit in the form of an annuity with the annuity settlement option, all wonderful, powerful strategies. And one I don't want you to forget is I mentioned GIAs. GIAs for non-registered assets, that income is not reported as interest income, but rather is reported as annuity income. And that's important because if you're over 65, non-reg annuity income qualifies for the pension income credit and pension income splitting. A significant advantage over and above all the other things I talked about with naming a beneficiary versus a bank or credit union GIC. So we have a bunch of articles on our website. They're available. These are all linkable. We have a great piece called Insurance Investments, the Facts. It is, I think, and I say this humbly, I think the best seg fund reference piece out there. But hopefully I've given you some insights, some information, some education, got you excited about this potential opportunity where you can help clients out there. And again, I want to thank you for your time and hope you enjoy the rest of your conference. Thank you very much for having me.